Section 202.33, Conduct of the Voir Dire. In this section, the trial judge is all references to the trial judge in this section shall include any judge designated by the administrative judge in those instances where the case processing system or other logistical considerations do not permit the trial judge to perform the acts set forth in this section. B. Pre-voir dire settlement conference, where the court has directed that jury selection begin. The trial judge shall meet prior to the actual commencement of jury selection with counsel who will be conducting the voir dire and shall attempt to bring about a disposition of the action. You don't know if anybody knows what voir dire means, but voir dire is when attorneys would ask questions of the jurors before they make their selections. Okay. Basically, that's what it is, in a nutshell. Okay. C. Method of jury selection. The trial judge shall direct the method of jury selection that shall be used for the voir dire from among the methods specified in subdivision F. D. Time limitations. Establish time limitations for the questioning of prospective jurors during the voir dire. The trial judge shall establish time limitations for the questioning of prospective jurors during the voir dire. At the discretion of the judge, the limits established may consist of a general period for the completion of the questioning, a period after which attorneys shall report back to the judge on the progress of their voir dire, and or specific time periods for the questioning of panels of jurors or individual jurors. E. Presence of judge at the voir dire. In order to ensure an efficient and dignified selection process, the trial judge shall preside at the commencement of the voir dire and open the voir dire proceeding. The trial judge shall preside at the commencement of the voir dire and open the voir dire proceeding. The trial judge shall determine whether supervision of the voir dire should continue after the voir dire has commenced and, in his or her discretion, preside over part of or all of the remainder of the voir dire. And that's different in criminal. F. Methods of jury selection. Counsel shall select prospective jurors in accordance with the general principles applicable to jury selection set forth in subdivision G of this section and using the method designated by the judge. The methods that may be selected are 1. White's method, 2. Struck method, 3. Strike and replace method. In districts where the specifics of that method have been submitted to the fucking chief administrator by the administrative judge and approved by the fucking chief administrator for that district, or 4. Other methods that may be submitted to the chief administrator for use on an experimental basis by the appropriate administrative judge and approved by the chief administrator. G. Procedures for questioning, challenging, and selecting jurors authorized by Section 202.33 of the rules of the fucking chief administrator of the courts. A. General principles applicable to jury selection. Selection of jurors pursuant to any of the following methods shall be governed by the following. 1. If for any reason jury selection cannot proceed immediately, counsel shall return promptly to the courtroom of the assigned trial judge or the trial assignment part or any other designated location for further instruction. Counsel shall return promptly for further instruction. 2. Generally, a total of 8 jurors, including 2 alternates, shall be selected. Okay. The court may permit a greater number of alternates if a lengthy trial is expected or for any appropriate reason. Okay, so generally a total of 8 jurors, including 2 alternates, shall be selected. The court may permit a greater number of alternates if a lengthy trial is expected or for any appropriate reason. Counsel may consent to the use of non-designated, in quotations, alternate jurors, in which event no distinction shall be made during jury selection between jurors and alternates, but the number of peremptory challenges in such cases shall consist of the sum of the peremptory challenges that would have been available to challenge both jurors and designated alternates. 3. All prospective jurors shall complete a background questionnaire supplied by the court in a form approved by the chief administrator. Prior to the commencement of jury selection, completed questionnaires shall be made available to counsel. Upon completion of jury selection or upon removal of a prospective juror, the questionnaires shall be either returned to the respective jurors or collected and discarded by court staff in a manner that ensures jury privacy. With court approval, which shall take into consideration concern for juror privacy, the parties may supplement the questionnaire to address concerns unique to a specific case. 4. During the voir dire, each attorney may state generally the contentions of his or her client and identify the parties, attorneys, and the witnesses likely to be called. However, counsel may not read from any of the pleadings in the action or inform potential jurors of the amount of money at issue. 5. Counsel shall exercise peremptory challenges outside of the presence of the panel of prospective jurors. 6. Counsel shall avoid discussing legal concepts such as burden of proof, which are the province of the court. 7. If an unusual delay or a lengthy trial is anticipated, counsel may so advise prospective jurors. 8. If counsel objects to anything said or done by any other counsel during the selection process, the objecting counsel shall unobtrusively request that all counsel step outside of the juror's presence, and counsel shall make a determined effort to resolve the problem. Should the effort fail, counsel shall immediately bring the problem to the attention of the assigned trial judge, the trial assigned part judge, or any other designated judge. 9. After jury selection is completed, counsel shall advise the clerk of the assigned trial part or of the trial assigned part or other designated part. Okay, if counsel anticipates the need during trial of special equipment, if available, or special assistance such as an interpreter, counsel shall so inform the clerk at that time. So this is stuff that a clerk would need to know. B. White's method. 1. Prior to the identification of the prospective jurors to be seated in the jury box, counsel shall ask questions generally to all of the jurors in the room to determine whether any prospective juror in the room has knowledge of the subject matter, the parties, their attorneys, or the prospective witnesses. A response from a juror that requires elaboration may be the subject of further questioning of that juror by counsel on an individual basis. Counsel may exercise challenges for cause at this time. 2. After general questions have been asked to the group of prospective jurors, jury selection shall continue in rounds, which each round to consist of the following. 1. Seating prospective jurors in the jury box. 2. Questioning of seated prospective jurors. And 3. Removal of seated prospective jurors upon exercise of challenges. Jurors removed for cause shall immediately be replaced during each round. The first round shall begin initially with the seating of 6 prospective jurors. Where undesignated alternates are used, additional prospective jurors equal to the number of alternate jurors shall be seated as well. 3. In each round, the questioning of the seated prospective jurors shall be conducted first by counsel for the plaintiff, followed by counsel for the remaining parties in the order in which their names appear in the caption. Counsel may be permitted to ask follow-up questions. Within each round, challenges for cause shall be exercised by any party prior to the exercise of peremptory challenges and as soon as the reason therefore becomes apparent. Upon replacement of a prospective juror removed for cause, questioning shall revert to the plaintiff. Following questioning and the exercise of challenges for cause, peremptory challenges shall be exercised one at a time and alternately as follows. In the first round, in caption order, each attorney shall exercise 1 peremptory challenges by remove prospective juror's name from a board passed back and forth between or among counsel. An attorney alternatively may waive the making of a peremptory challenge. An attorney may exercise a second single peremptory challenge within the round only after all other attorneys have either exercised or waived their first peremptory challenges. The board shall continue to circulate among the attorneys until no other peremptory challenges are exercised. An attorney who waives a challenge may not thereafter exercise peremptory challenge within the round, but may exercise remaining peremptory challenges in subsequent rounds. The counsel last able to exercise a peremptory challenge in a round is not confined to the exercise of a single challenge, but may then exercise 1 or more peremptory challenges. 5. In subsequent rounds, the first exercise of peremptory challenges shall alternate from side to side. Where a side consists of multiple parties, commencement of the exercise of peremptory challenges in subsequent rounds shall rotate among the parties within the side. In each such round, before the board is to be passed to the other side, the board must be passed to all remaining parties within the side, in caption order, starting from the first party in the rotation for that round. 6. At the end of each round, those seated jurors who remain unchallenged shall be sworn and removed from the room. The challenged jurors shall be replaced, and a new round shall commence. The selection of designated alternate jurors shall take place after the selection of the 6 jurors. Designated alternate jurors shall be selected in the same manner as described above, with the order of exercise of peremptory challenges continuing as the next round, following the last completed round of challenges to regular jurors. The total number of peremptory challenges to alternates may be exercised against any alternates regardless of seat. Struck method. 1. Unless otherwise ordered by the court, selection of jurors shall be made from an initial panel of 25 prospective jurors who shall be seated randomly and who shall maintain the order of seating throughout the voir dire. If fewer prospective jurors are needed due to the use of designated alternate jurors or for any other reason, the size of the panel may be decreased. 2. Counsel first shall ask questions generally to prospective jurors as a group to determine whether any prospective jurors has knowledge of the subject matter, the parties, their attorneys, or the prospective witnesses. A response from a juror that requires further elaboration may be the subject of further questioning of that juror by counsel on an individual basis. Counsel may exercise challenges for cause at this time. 3. After the general questioning has been completed, in an action with one plaintiff and one defendant, counsel for the plaintiff initially shall question the prospective jurors, followed by questioning by defendant's counsel. Counsel may be permitted to ask follow-up questions. In cases with multiple parties, questioning shall be undertaken by counsel in the order in which the parties' name appear in the caption. A challenge for cause may be made by counsel to any party as soon as the reason therefore becomes apparent. At the end of the period, all challenges for cause to any prospective juror on the panel must have been exercised by respective counsel. 4. After challenges for cause are exercised, the number of prospective jurors remaining shall be counted. If that number is less than the total number of jurors to be selected, including alternates, where non-designated alternates are being used, plus the maximum number of peremptory challenges allowed by the court or by statute that may be exercised by the parties, such sum shall be referred to as the jury panel number in quotations. Additional prospective jurors shall be added until the number of prospective jurors not subject to challenge for cause equals or exceeds the jury panel number. Counsel for each party then shall question each replacement juror pursuant to the procedure set forth in paragraph 3. 5. After all prospective jurors in the panel have been questioned and all challenges for cause have been made, counsel for each party, one at a time, beginning with counsel for the plaintiff, shall then exercise allowable peremptory challenges by alternately striking a single juror's name from a list or ballot passed back and forth between or among counsel until all challenges are exhausted or waived. In cases with multiple plaintiffs and/or defendants, peremptory challenges shall be exercised by counsel in the order in which the parties' names appear in the caption, unless following that order would, in the opinion of the court, unduly favor a side. In that event, the court, after consulting with the parties, shall specify the order in which the peremptory challenges shall be exercised in a manner that shall balance the interests of the parties. An attorney who waives a challenge may not thereafter exercise a peremptory challenge. Any Batson or other objections shall be resolved by the court before any of the struck jurors are dismissed. 6. After all peremptory challenges have been made, the trial jurors, including alternates when non-designated alternates are used, then shall be selected in the order in which they have been seated from those prospective jurors remaining on the panel. 7. The selection of designated alternate jurors shall take place after the selection of the 6 jurors. Counsel shall select designated alternates in the same manner set forth in these rules, but with an initial panel of not more than 10 prospective alternates unless otherwise directed by the court. The jury panel number for designated alternate jurors shall be equal to the number of alternates plus the maximum number of peremptory challenges allowed by the court or by statute that may be exercised by the parties. Total number of peremptory challenges two alternates may be exercised against any alternate regardless of seat.